committee for the Omnibus liquor bill, Senate File 3008. For the record, it is 6 minutes after 7, and it is May 16th. And Lauren, would you take the roll?
Chair Dahms.
Here.
Chair Stevenson.
Here.
Senator Housley.
Here.
Senator Jasinski. Senator Kent.
Here.
Senator Uckey.
Here.
Representative Cotiza Wittoon.
Present.
Representative Nash.
Present.
Representative Olson.
Present.
Representative Wolgamott.
Present.
Senator Jasinski.
Thank you, Lauren. Members, we have a quorum. So tonight what I'd like to do is go through the side-by-side. And so if the House would like to start on that presentation, and that will be the issue, the issue of business this evening.
Mr. Chair, Chris Klayman from the House Research Department. So starting with the side-by-side, there's 3 articles in the House bill. Article 1 is related to liquor regulation. Sections 1 and also a portion of Section 3 relate to distilled spirits manufacturers. Section 1 provides a definition of distilled spirits manufacturers. And that in Section 3, those distilled spirits manufacturers are then allowed to operate a cocktail room if they otherwise meet the cocktail room requirements. Section 2 provides a new definition or an updated definition for malt liquor to define malt liquor as allowing malt substitutes. In addition, it also clarifies that as used throughout the liquor chapter, Chapter 340A, the word beer refers to malt liquor. Section 3 relates to distilled spirits manufacturers and micro distilleries. These are the cocktail room provisions. This section does 3 things. Again, it allows a distilled spirits manufacturer who, and again, that definition defines a distilled spirits manufacturer as a manufacturer of distilled spirits who manufactures more than 40,000 proof gallons of spirits per year. They could operate a cocktail room. It also excludes certain spirits bottled under a third-party bottling contract from the 50% annual production threshold that's required in order to operate a cocktail room for a microdistillery. And last, this section also expands the range of container sizes that may be sold off sale by microdistilleries.
And I can no longer hear from the Zoom.
I guess I'll.
Thank you.
Mr. Chair.
Yes, Representative Stevenson.
Thank you, Mr. Chair. I think, Mr. Klayman, are you in the Zoom on your computer? Perhaps if you entered the Zoom meeting, Representative Cotiza Wittoon could hear you through that.
My apologies, Mr. Chair and Chair Stevenson. Let me do that.
Mr. Chair, I can hear fine now. It just looked like the main computer at the front desk went on mute and the sound had stopped. But now it's unmuted and I seem to hear just fine.
Okay. Technical difficulties, Mr. Chair. We'll get in just 1 sec. 3, 4, 5. Okay. Oh. So moving on to the third thing in Article 1, Section 3, this expands the range of container sizes for microdistillery off sales. And essentially, the microdistilleries could choose to sell to a customer per day either up to 750 milliliters of distilled spirits or up to 1.125 milliliters of distilled spirits. And for the 750 milliliter option, those containers could be sold in any size container that's approved by the Commissioner of Public Safety. However, under the 1.125 option, the container sizes would have to be in amounts of 375 milliliters or less. Section 4 is the provision relating to growlers. This would increase the threshold for the sale of growlers from 20,000 barrels per year to 150,000 barrels per year, so a small brewery making 150,000 barrels of beer or less would be able to sell growlers. Section 5 creates off-sale packaging requirements for certain brewers. These would be new provisions. They would allow a small brewer, which is defined as a brewer producing 7,500 barrels or less of malt liquor per year, to make off sales up to 128 ounces, in addition to what they're already able to sell under the current off-sale growler provisions. Those off sales could be in any sized container that's approved. And there are a couple other provisions related to this. One is that the brands that are sold under this expanded off-sale provision would have to be made available to wholesalers. And there's also a provision that allows other small breweries between 5,500 and 13,500 barrels of annual production to make these additional sales until their production increases by 2,000 barrels over their 2021 production level. Section 6 relates to self-distribution for wineries that produce cider. So this provision would allow a winery that produces apple-based cider to self-distribute that cider, provided that no more than 2,500 barrels is produced in a calendar year. And the winery would also have to provide an affidavit to the Commissioner of Public Safety stating that no wholesaler is available to distribute the cider. Sections 7 through 9 relate to the Coleman Act. And Mr. Chair, I guess I could turn this over to Mr. Stang if you wanted to do the Senate provision on that.
Mr. Chairman, I'm happy to give Mr. Klayman a short breather here. As you see, the Senate bill's a little thinner than the House bill. But these three sections on each side, they're identical, deal with amendments to the Coleman Act. And basically what they do is apply Minnesota's open wholesaling law to in-state manufacturers of distilled spirits. And these statutes are in response to some federal Commerce Clause litigation. As it stands now, it's pretty clear that this discriminates against out-of-state manufacturers. So these sections are intended to respond to that. And again, they're the same in the House and the Senate.
Then, Mr. Chair, Section 10 of the House bill, this includes provisions relating to on-sale licenses for resorts and for town ball games. The first provision allows a city to issue an on-sale intoxicating liquor license to a resort, and the second allows a municipality, which would include a county, could issue a wine or malt liquor license to the owner of a town ball team for sales at town ball games. Section 11 allows counties to issue an on-sale intoxicating liquor license to an auto racing facility. It's something that cities can already do. Section 12, this is related to Section 10 of the House bill that authorizes counties to issue the on-sale licenses for resorts. Sections 13 and 14 relate to temporary on-sale licenses for county fairs. And there's actually two things that Section 14 does as well, but the first one, it allows a municipality to issue a temporary on-sale license that's good for 7 days. Right now, the maximum number of days that a temporary on-sale license is valid for doesn't go up to 7 days. And then Section 13 is a conforming change to that provision. The other thing that Section 14 does is it strikes the 30-day waiting period for any one organization or any one place for the issuance of a temporary on-sale license. Section 15 allows an exclusive liquor store to sell citrus fruits and glassware. Section 16 allows extended on-sale hours during live World Cup matches. These would be FIFA men's and women's World Cup matches. And they'd have to apply for a permit, and the localities would retain some authority on the permit as well. Section 17, this would create a liquor advisory regulation or liquor regulation advisory council. This would be composed of 12 members appointed by the governor. There may be a House summary out there that errantly says it's 9 members that is being corrected and should be posted shortly. But it's 12 members, 4 of them would, and there'd be 3 groups that the governor would appoint members for, representing retailers, wholesalers, and manufacturers. On the retailer side, there'd be 1 representative from the municipal liquor stores, 1 from exclusive liquor stores, 1 from restaurants, and 1 from essentially grocery stores. On the wholesale side, there would have to be a representative from organized labor, 1 for distilled spirits wholesaling, 1 for beer wholesaling, and then any wholesaler. And for manufacturers, the 4 members would be composed, 1 who represents small brewers, 1 who represents micro distilleries, 1 who represents farm wineries, and then any other manufacturer than those other 3. And the Liquor Council would be required to make certain recommendations regarding proposed changes to state liquor law, but only those changes that would have a statewide impact, so it wouldn't affect special laws. And then they'd have to report to the legislative committees on the recommendations. There are also provisions relating to meetings, voting. The Commissioner of Public Safety would also have to, would be the executive director and would have to provide administrative support as well. Section 18, temporarily for 2 years, allows a person who is 17 years of age to serve and sell alcohol, provided that that individual does not tend bar. Section 19 creates an appropriation in the amount of $250,000 to the Commissioner of Public Safety to hire 2 additional full-time employees for the Alcohol and Gambling Enforcement Division. And Mr. Chair, that concludes Article 1.
Thank you. Would you like to continue in Article 2?
Yes, Mr. Chair. Moving on to Article 2. All the provisions in Article 2 relate to the proposals for direct shipped wine. Under Minnesota law, wineries can ship up to 2 cases per customer per year, or to a customer per year, to a Minnesota resident per year. The direct ship wine provisions would move that 2-case limit to 12 cases, so up to 12 cases per resident per year, and would also provide for a number of regulatory changes as well, and would also require the direct ship wine shippers who are not currently paying various taxes to also pay those taxes. And I can briefly go through the sections, Mr. Chair. Section 1 is a data practices cross-reference to the provisions in sections 8 and 9. Sections 2 through 4 relate to tax collection. Section 2 requires a direct ship winery to collect the alcohol gross receipts tax. That's a 2.5% tax that retailers pay. Section 3 requires the direct ship wine shippers to collect and remit the sales and use tax. And Section 4 would eliminate the current exemption for the wine excise tax for direct wine shippers. Section 5 allows funds to be appropriated from the alcohol enforcement account to enforce the direct wine ship regulations. Section 6 applies the current direct ship winery suspension and revocation provisions to the direct ship winery licensees. Section 7, this provides the increase in the number of cases that a direct ship winery may ship to a Minnesota resident from 2 to 12, and would also apply the current penalties that exist for violating direct ship wine laws to those shippers. Section 8 is the main regulatory provision of the direct ship wine law. This would establish definition for direct ship purchasers and direct ship wineries. Direct ship wineries are defined as not a licensed out-of-state winery that sells and ships wine to a direct ship purchaser who would be a resident of, or a Minnesota address resident of Minnesota. Section 2 establishes license requirements. To obtain a license, a direct ship winery under the proposal would have to provide a copy of its license, its outbound shipping address list, agree to pay the required state taxes, and submit to the jurisdiction of Minnesota courts. Subdivision 3 prohibits a direct ship winery from shipping wine from any address other than the address provided to the commissioner, or from a third-party purchaser that hasn't been, whose name and address has not been provided to the Commissioner of Public Safety. And also states that only wine from the direct ship winery's own production can be shipped under these provisions. Again, Subdivision 4 requires the direct ship winery to collect and pay all the taxes previously mentioned. Subdivision 5 classifies the data as private data for the reporting provisions under this section. And then Subdivision 6 is another enforcement and penalty provision that imposes current penalties to violations of this main regulatory provision. Section 9 of Article 2 requires common carriers to file a monthly report with the commissioner detailing the shipments of wine that the carrier has made into the state, and would require those records to be retained for 2 years, and would also impose a $500 fine for violations by the common carriers. And again, there's another data classification provision in that section as well. And then Section 10, this creates 2 appropriations, one in fiscal year of $568,000 in fiscal year 2023 to the Commissioner of Public Safety to administer the direct ship wine provision, and then another $166,000 appropriation in fiscal year 2023 to the Commissioner of Revenue to administer the same provisions. And the base appropriations for the Commissioner of Public Safety are $441,000, and for the Commissioner of Revenue it would be $130,000. Those would be the base appropriations in 2024 and 2025. And that concludes House Article 2. And I can move into House Article 3, Mr. Chair.
Please do so.
Article 3 are the special local laws, local liquor laws, and there are 7 provisions in Article 3. The first is an on-sale license for the city of Willmar. That would be a wine or malt liquor license that the city could issue to a junior league hockey team owner for events at the Willmar Civic Center. Section 2 allows the city of Sauk Rapids to issue a liquor license, an intoxicating liquor license for 2 parks, Bob Cross Regional Park and Lions and Southside Park, for events at those parks. Section 3 allows the city of St. Paul to issue a temporary malt liquor license to the Thai Cultural Council of Minnesota for their festival, St. Paul. Section 4 allows the city of St. Cloud to issue an on-sale beer or wine license to the Whitney Recreation Facility for events at that park. Section 5 is a special provision for the city of Anoka. This would allow the city of Anoka to issue a new social district license. That license could be issued to a current holder of an on-sale license, and it would allow for consumption of alcoholic beverages sold by that on-sale licensee in a designated social district area. And there's a contiguity requirement there too, so the on-sale licensee premises would have to be contiguous with the with the social district premises. That's subdivision 1 of section 5. Subdivision 2 just requires the city to designate that social district area before they issue the license. And they'd have to include the hours and days where consumption would be allowed in the social district. Section 3 would require signage within the social district delineating where the social district is and providing information about the local law enforcement agency that's in charge of enforcing the liquor laws in that district. And also include a statement saying that individuals cannot take alcoholic beverages out of the social district. Subdivision 4 would require the city of Anoka to implement a maintenance plan for the district for the benefit of the public. Subdivision 5 establishes some additional requirements for the on-sale licensees who could obtain a social district license. And would prohibit and part of this would be prohibiting customers from entering an on-sale licensee's establishment with another on-sale licensee's alcoholic beverage unless, but individuals could still go back into that on-sale licensee's establishment with an alcoholic beverage that on-sale licensee sold to them. This subdivision also would establish container and labeling requirements for the alcoholic beverages that are going to be consumed in the social district. Lastly, subdivision 6 establishes other additional social district requirements. Again, the contiguity requirement is also reiterated in the subdivision and just states that the beverages can only be possessed or consumed in the social districts. The containers have to meet the labeling requirements, and that those alcoholic beverages can only be possessed and consumed within the hours and days set by the city. Section 6 then is a special license for the city of Rochester. It allows the city to issue an on-sale wine or malt liquor license for the McQuillan Park softball complex for events at the complex. And lastly, Mr. Chair and members, Section 7 allows the city of Alexandria to issue an on-sale wine or malt liquor license to a junior hockey league team owner for sales and events at the Runestone Community Center in that city. And Mr. Chair, that concludes the walkthrough.
Well, thank you, Mr. Clayman. And members, any questions for either one of the presenters, Mr. Clayman or Mr. Casey? Get this right, it's not Casey. Mr. Stang. Any questions, members? Chair Stevenson.
Thank you, Mr. Chair. I just, it's not so much a question, I just want to, I think most of the provisions in the House bill are pretty self-explanatory, but there was one that I just did want to offer some comment on, and that is the appropriation that is in Article 1 to create 2 new positions at the Alcohol Gambling Enforcement Division. That's Section 19, which you can find on R12.
Page
R12.
Yeah.
So Section 19 on R12 appropriates $250,000 from the general fund to the Commissioner of Public Safety for the purpose of hiring 2 additional full-time employees at AGED. And the reason for that appropriation is that with some of the expansion of off-sale that is occurring in this bill, the thought and the nature of the compromise was that AGED might have more enforcing obligations to make sure that those rules are being adhered to. And it made sense to have more enforcement agents. So I just wanted to, for the committee's knowledge, why that appropriation was in the House version of the bill.
Well, thank you, Chair Stevenson. We appreciate the explanation. Members, any other questions? Seeing none, Chair Stevenson, do you have any final comments?
Thank you, Mr. Chair. Look forward to talking with you further about this in future days.
Well, thank you, members, and that concludes the business for this evening, and I'm sure that we'll be getting a hold of you to set up some future meetings, so thank you very much for attending, and look forward to getting something worked out. The committee is now adjourned.